In this lecture, we shall continue with our discussion on unilateral mistakes, specifically establishing mistake as to the identity of the contracting party. We have already discussed how to establish mistake as to the identity of the contracting party when a transaction was not done face to face. But in a transaction, and as we have said, if it's not done face to face, the focus, that is if it's in writing, as we've seen in Candy and Lindsay, and then Keynes Norton, Metal Company versus Edrich, Merit and Co. Limited. If it is not in writing, the focus of the court becomes whether the transaction, whether the sellers had in mind a definite and identifiable party with whom they intended to contract, and not the rook. That is the focus of such discussions. If there's a definite and identifiable person in mind, it is possible the transaction may be declared void. But what about if the transactions were face to face? That is what we now have to discuss at this point in time. Now, if it is face to face, I'll begin first by reading the position of the law as captured on page 64 of the book titled Contract Law, 15th edition, authored by A1 McKendrick. Page 64, this is what the learned author states, and I quote, "Where parties deal with each other in a face-to-face transaction, the law presumes that each party to the transaction intends to deal with the party in front of him. Where the parties deal with each other in a face-to-face transaction, the law presumes that each party to the transaction intends to deal with the party in front of him. Thus, the fact that one party to the contract claims that he is mistaken as to the true name and hence identity of the party who was in front of him will not suffice to render the contract void." Again, where the parties deal with each other in a face-to-face transaction, the law presumes that each party to the transaction intends to deal with the party in front of him. Thus, the fact that one party to the contract claims that he is mistaken as to the true name and hence identity of the party who was in front of him will not suffice to render the contract void. This is a very serious statement. End of quote. This is a very serious statement. It means that if you transact in each other's presence in a face-to-face transaction, the law presumes that you intend to deal with the one you saw by sight and by hearing. And the fact that you claim to have been mistaken will be of no effect. We would still deem that you intended to deal with the one you saw by sight and by hearing, where the person was in front of you. So the fact that somebody comes to you and tells you that Kwame Mensah, head of this company, so long as you saw him face to face, even if you had in mind that there was somebody called Kwame Mensah somewhere, it's of no effect. It will not render the agreement void. It will only render it voidable. It will presume that you intended to deal with the one you saw by sight and by hearing, and we don't care whether you had in mind somebody in existence called Kwame Mensah. The point is made clearer when you read Christine Dowonamon's book, titled The Law of Contracts in Ghana, at page 197 and 198. This is what she says, and I quote, "Where the parties deal with each other face to face, with one party fraudulently misrepresenting himself to be another existing person, there's a strong presumption that the offeror intended to contract with the person who was physically present and no one else. There's a strong presumption that the offeror intended to deal with the person who was physically present and no one else." End of quote. You know why this is so? If there's a strong presumption, it means that the transaction that you have entered into with the rook, it will not be void on grounds of mistake. It will rather become voidable. And we don't care whether you had in mind somebody who met the description that he gave. No. Once it was face to face, the presumption is that you intended to deal with the one you saw by sight and then by hearing. The principle is made clearer in the case of Phillips and Brooks, which we shall discuss shortly. And I'm reading the facts and holding from Christine Dowonamon's book, which you can see from page 197 to 198. Phillips and Brooks, this is what the court, this is what you see from the book, and I quote: a man named North called in person at the plaintiff's shop and selected some pearls and a ring. Selected some pearls and then a ring. He then wrote a check for £300 saying, I am Sir George Bullock, and gave an address. Let me pause here and give you a hint. It says called in person, meaning this one is a face-to-face transaction, right? And remember the presumption. Now, when it is face-to-face, there is a strong presumption that you intend to do with the one you saw by sight, by hearing. And we don't care whether there's somebody somewhere who matches the description or not. Now, let's take the facts again. Phillips and Brooks. A man named North called in person at the plaintiff's shop and selected some pearls and a ring. He then wrote out a check for £300 saying, I am Sir George Bullock, and then gave an address. The plaintiffs knew of one Sir George Bullock as a person of high standing and credibility. They checked the directory to confirm that the address given by the man was indeed the address of Sir George Bullock. Upon confirming that it was, the plaintiffs allowed North to take the ring away and accepted his check. I'm pausing here to comment. So indeed, the plaintiff knew of one Sir George Bullock and checked the directory and realized that the address that the person gave, the road gave, was indeed the address of Sir George Bullock. It means that there was somebody in existence called Sir George Bullock. Let's see what the court will say. North then pledged the ring to the defendants for £350. The check was dishonored. Then the plaintiff then sued the defendants for the return of the ring, alleging that in the circumstances they never intended to sell the goods to North, but rather to Sir George Bullock. Let's look at our diagram again and see. Plaintiff with the seller, rook is North, and the third parties. Now the rook says, I am Sir George Bullock. Then give you a check. Then plaintiff, you give the goods to the rook. The rook now gives to the third party and vanishes. The check has been dishonored. Now the plaintiff is suing the third party and wants to recover from the third party. Can the plaintiff recover or not? Remember the principle that I give. That if you transact in each other's presence, there's a strong presumption that you intend to do with the one you saw by sight and by hearing. And therefore the resulting contract will not be deemed to be void on grounds of mistake, but rather be deemed to be voidable. Let's see what the learned author states at page 198 of her book. The court held that the presumption applied to these facts and held that even though the plaintiffs believed that the person to whom they handed the ring was Sir George Bullock, nevertheless they intended to contract with the person who came into their shop, who they identified by sight and by hearing. The contract made was not void, but simply voidable on grounds of misrepresentation. Thus, the rook obtained a title which was valid until disaffirmed by the plaintiffs. Thus, the rook obtained a title which was valid until disaffirmed by the plaintiffs. Since the plaintiff had not avoided the rook's title, by the time he sold the goods to the third party, the latter obtained a valid title to them, and the owners could not recover the goods from the third party. Again, as between the sellers and the rook, the court has found that argument becomes what? Voidable. And if it is voidable, you know what it means. It means that it remains valid unless and until you take steps to rescind the transaction. And now we found at the time that the goods were sold to the third party, the transaction had not been rescinded. So the seller would acquire a valid title, and therefore the owner will not be able to recover the goods from the third party. This is something that you have to bear in mind as far as this transaction is concerned. Because it was face-to-face, the court took the view that the transaction will not be deemed to be void on grounds of mistake, but rather be deemed to be what? Voidable on grounds of the misrepresentation. And if it was voidable, it means that it will be valid unless it is rescinded. Since it was transferred, at the time it will not be rescinded. The transaction does not become void. So the third party acquired a valid title, which the owner can therefore not recover. I'm reading the holding again, which you can glean from page 198 of Christian Doe-Narmon's book. This is what the learned author states, and I quote. The court held that the presumption applied to these facts and held that even though the plaintiffs believed that the person whom they handed the ring was Edward Bulloff, nevertheless, they intended to contrast with the person who came into their shop, who they identified by sight and hearing. The conduct made was therefore not void, but simply voidable on grounds of fraudulent misrepresentation. Thus, the rogue obtained a title which was valid until disaffirmed by the plaintiffs. Since the plaintiff had not avoided the rogue's title, by the time he sold the goods to a third party, the latter obtained a valid title to them, and the owners could not recover the goods from the third party. Let's compare this case to that of Ingram and Little. And please, by the time I go through this case, you indeed need to have a comment. If you are following the discussion well, when I finish discussing this particular case, you should have a comment. You should have an opinion about whether the decision was correct or was wrong. And so if you know that you haven't gotten the firm grip of the principles we've already discussed from Phillips and Brooks, make sure you go over and then you're on top of your game before we look at this Ingram and Little, because you must have a position about it, and your position must be correct. Based on how clear and how explanatory it is, I'm reading from Christian Doe-Narmon's book titled Law of Contracts in Ghana at page 198. This is what you get from Ingram and Little, and I quote. A rogue calling himself Hutchinson went to the residence of the plaintiffs and negotiated for the purchase of their car, which they had advertised for sale. A rogue calling himself Hutchinson went to the residence of the plaintiffs, then went there to negotiate for the purchase of their car, which they had advertised for sale. The plaintiffs agreed to sell it to him for £717, and the rogue proposed to pay by check. The plaintiff declined to sell the car to the rogue, at that point stating that they would not under any circumstance accept a check. Let me pause and comment. Bear in mind, this is actually a transaction which they are dealing with face-to-face. Remember the presumption. The presumption is that if you transact face-to-face, there's a strong presumption that you intend to deal with the one you saw by sight and then by hearing. The transaction you enter into, therefore, will not become void. It will become voidable. Based on now that you have refreshed your memory about the principle, let me begin the facts again and be very alert, because this is a transaction that was the face-to-face transaction. Ingram and Little. A rogue calling himself Hutchinson went to the residence of the plaintiffs and negotiated for the purchase of their car, which they had advertised for sale. The plaintiffs agreed to sell it to him for $717, and the rogue proposed to pay by check. The plaintiffs declined to sell the car to the rogue, at that point stating that they would not under any circumstances accept a check. The rogue then told the plaintiffs that he was PGM Hutchinson with business interests in Guildford and gave them his home address. On hearing this, one of the plaintiffs slipped out of the room, consulted the telephone directory to check that there was not a person as PGM Hutchinson, and to verify that the address given by the rogue was in fact the address of PGM Hutchinson. Being reassured, the plaintiffs, who had never previously heard of PGM Hutchinson, agreed to sell the car to the rogue. The rogue, who was not PGM Hutchinson, later sold the car to the defendants and disappeared. The court held in this case that on the facts, the plaintiffs intended to deal with PGM Hutchinson only and not the rogue. Therefore, the rogue could not accept the offer. It was therefore held that the contract between the plaintiffs and the rogue was void on grounds of mistake as to identity, and the rogue acquired no title to the car and transferred no title to the third party. who was required to return the car to the owner. As I indicated earlier, if you understand the case of Phillips and Brooks, by now you should have some questions to ask about this case of Ingram and Little. Was this case rightly decided? Do you have any questions? Let's take a look at the facts once again. Ingram and Little. Averay, calling himself Hutchinson, went to the residence of the plaintiffs, so he went in person. They went out to negotiate for the purchase of their car, which they had advertised for sale. So it was a face-to-face transaction. So if it's a face-to-face transaction, it means that the presumption is that you intend to deal with the one you saw by sight and by hearing. The transaction is therefore not supposed to be void. It's supposed to be voidable. So why is the court going ahead to say that this one is also then becoming void? Because in Phillips and Brooks, similar facts. In Phillips and Brooks, we realized that it was face-to-face. And we came to the conclusion that because it was face-to-face, then the presumption applied. So the transaction became voidable. Why is it that in Ingram and Little, they are saying that it is face-to-face, but it becomes void? I want to know the questions you have. But while you think about the questions, look at the page 199 of the book titled Law of Contracts in Ghana, authored by Christian Dowona Hammond. And this is what it says at page 199. But it is interesting to note, however, that in Lewis and Avery, which is the most recent case on the issue, the court declined to follow the decision of the court in Ingram and Little and apply the reasoning in Phillips and Brooks. It means that the court have declined to follow the decision in Ingram and Little because they did not give a decision which was in accordance with the principles that we all know of. So if you had questions about Ingram and Little, the good news is that in Lewis and Avery, which is the most recent one, they did not follow the Ingram and Little. They rather went back to the Phillips and Brooks. So if you have a question, you are answering the question, bear in mind that you have Lewis and Avery. You also have Phillips and Brooks, which are in line with the general principle. And some books have actually taken the position that Ingram and Little was wrongly decided. But let's leave it as such. And then let's say that we are relying on Lewis and Avery, and then Phillips, and then Brooks. What happened in Lewis and Avery? Let's see how they followed Phillips and Brooks. Averay posing as Richard Green, the well-known film actor. And remember, I'm reading from page 199 of the book titled Law of Contracts in Ghana, authored by Christian Dowona Hammond. Lewis and Avery. Averay posing as Richard Green, the well-known film actor, called on the plaintiff and offered to buy his car, which had been advertised for sale. The plaintiff accepted the offer and was given a check signed R.A. Green. Emphasis, also an in-person transaction. The plaintiff, afraid that the check might be worthless, refused to allow the rogue to take the car away immediately. The rogue, in order to prove that he was in fact Richard Green, produced a special pass of admission to Pinewood Studios, bearing an official stamp. Satisfied with this, the plaintiff handed over the logbook and allowed the rogue to take the car away. The check, which had been stolen, was dishonored, and the rogue sold the car to the defendants. The plaintiff then brought an action to recover the car from the third party who had bought it from the rogue. As usual, let's look at this from our diagram. Lewis and Avery. So the owner sold the car, and I've emphasized that the rogue called in person, and therefore the transaction was face-to-face. So the Lewis and Avery, the owner sold the car to the rogue, posing as Richard Green. And then while he was posing as Richard Green, he gave a check. And then when he gave a check, and then the check was given to the sellers gave him the car. Then he quickly sold the car to the defendant, and then he ran away. Now the owners have seen the car in the hands of the third party. The check has been dishonored, and they want to find out whether they can recover the goods from the third party or not. What do you think in this case? If I say they followed Phillips and Brooks, you know what will happen? That because it was a face-to-face transaction, the presumption will be that the sellers intended to deal with the one they saw by sight and by hearing, which is the rogue. And therefore the transaction will not become void, which will rather become voidable. If it is voidable, it means that the rogue had valid title, which you could transfer to the third party, unless the owners had rescinded it before the transfer was done. in this case, the owners have not rescinded it before the road gives the third party. So it means that since they have given to the third party, then the owners cannot recover from the third party. Because under a voidable transaction, the road acquires a valid title, which it gives the third party. So it means that the owner will not be able to recover the goods, Lewis and then Avery. Let's see what the letter order states at page 199 of her book. She says as follows, and I quote, "The court held that the action must fail. The court applied the presumption that where parties transact face to face, the offeror is deemed to have intended to contract with a person who was physically present and no one else. The presumption was not rebutted by the fact of this particular case. The contract between the owner and the rogue was therefore not void for mistake, but simply voidable by reason of the rogue's fraudulent misrepresentation. And therefore the third party obtained a valid title." This is the case of Lewis and Avery. So because it was a face-to-face transaction, the court applied the presumption that once it was face-to-face, then the presumption would be that you intend to deal with the one you saw by sight and by hearing. Therefore, the transaction will not become void, it will rather become voidable. If it is voidable, what does it mean? That the rogue will acquire a valid title, which can be transferred to the third party, unless the owners have taken steps to rescind it before the rogue transfers to the third party, who buys for value in good faith without notice of the defective title. What will be our recap then of contract inter parentes? The general principle is that when parties transact face to face, there's a strong presumption that the owner or the seller intended to deal with the one he saw by sight and by hearing. And therefore the transaction entered into between the owner and then the rogue will not become void on grounds of mistake, but rather become voidable. And the authorities are Phillips and Brooks and Lewis and Avery. Because remember, in Phillips and Brooks and Lewis and Avery, because it was face to face, the court took the view that the transaction will remain voidable. And by voidable, what does it mean? It means that it will remain valid unless steps have been taken to rescind that particular transaction. Now bear in mind, when we are dealing with these face-to-face transactions, all the principle that we state, look at this word over here. It says that there must be a strong presumption. When you say strong presumption, what does it mean? It means that it is only a presumption that you intend to deal with the one you saw by sight and by hearing, and that there are circumstances under which the presumption can be rebutted. So this presumption is not a conclusive presumption, it is a rebuttable presumption. And when you say it's a rebuttable presumption, it means that even though we are stating that we'll presume it to have intended to deal with the one you saw by sight and by hearing, that presumption can be rebutted by the facts of a particular case. So it is true that when you deal with each other face to face, the presumption is that you intend to deal with the one you saw by sight and by hearing. But like I'm saying, that presumption, it can be rebutted on the facts of a particular case. So just know that the general principle you have on Phillips and Brooks and Lewis and Avery, it is to the effect that once the transaction was face to face, there's a presumption that you intend to deal with the one you saw by sight and by hearing. The transaction therefore will not become void, it will become voidable. But that presumption is what? It's rebuttable. If it's rebuttable, what do we mean by that? It means that evidence can be led to prove the what? The contrary. So, if you read Christine Dowona Hammond's book titled The Law of Contracts in Ghana, at page 199 and 200, this is what the learned order states. There are certain circumstances in which the law recognizes that the presumption which applies in face-to-face contracts is effectively rebutted. Where the rogue dishonestly claims that he's acting as an agent for another person, a supposed principal, the presumption which applies in contract inter parentes will be deemed to be rebutted. In such a situation, there is no contract between the owner and the rogue, even though they transact in each other's presence, because the contract is not purported to be made with the rogue himself, but with a supposed principal. There is also no contract with the supposed principal, since the rogue, in fact, had no authority to act on his behalf. The apparent contract made, even though the parties transacted face to face, is therefore void. What do you mean by this? What we mean is that when you deal with each other face to face, the presumption that applies that you intend to deal with the one you saw by sight and by hearing, it is rebutted when the rogue was claiming to be an agent of another person. Because if I go to the shop and I go and say that, oh, I am the agent of Mr. Kwame Manfi, and I'm ordering 100 bags of cement. Remember, Kwame Manfi has not even authorized me to be his agent. But I've gone to the shop and I've gone to order goods in the name of Kwame Manfi. In that instance, first of all, since I didn't have even the instructions of Kwame Manfi to go and order the goods, the seller cannot say that he has an agreement with Kwame Manfi. And we cannot also say that the seller intended to deal with the rogue too, because the rogue was not claiming to be acting for himself, because he was claiming to act as an agent for somebody, when in fact he did not have any instructions of that particular principal to also act on his behalf. That's why I say that where the rogue dishonestly claims that he's acting as an agent for a supposed principal, the presumption which applies in conduct interpretantes will begin to be rebutted. And that is that there's no contract between the owner and the rogue. So we will not say that, oh, you intend to deal with the one you saw by sight and by hearing. No. Because, first of all, the one you are dealing with, he says he's an agent of Kwame Manfi. Meanwhile, he doesn't even have the instructions of the Kwame Manfi to deal. So we can't say that you intend to deal with the one you saw by sight and by hearing. So that a transaction will therefore not become voidable, which will become void. So look, he said that inside the situation, there's no contract between the owner and the rogue, even though they transact in each other's presence, because the contract is not purported to be made with the rogue himself, but with the supposed principal. There's also no contract with the supposed principal, since the rogue, in fact, had no authority to act on his behalf. The apparent contract made, even though the parties transacted face to face, is therefore void. Let us see how the court applied this in the case of Hardman versus Booth. The plaintiff visited the offices of Gandel and Sons and met one Edward Gandel, the rogue. Edward Gandel was not a member of the firm of Gandel and Sons and had no authority to act on his behalf. Remember, I'm reading the case of Hardman and Booth, and I'm still reading from the book titled The Law of Contracts in Ghana, written by Christian Dona Hammond from page 199 and 200, Hardman and Booth. And we are reading this case in the context of the rebuttal to the presumption that applies in contract interpretantes. Hardman and Booth. The plaintiff visited the offices of Gandel and Sons and met one Edward Gandel, the rogue. Edward Gandel was not a member of the firm of Gandel and Sons and had no authority to act on his behalf. He convinced the plaintiff that he was authorized to act as agent for the firm and gave the plaintiff an order in the name of the company. The plaintiff supplied the goods, which were intercepted by the rogue and sold to an innocent third party. The plaintiff then sued to recover the goods from the third party. Remember from the fact, he was purporting to be an agent. So are we supposed to say that the seller intended to deal with the one he saw by sight and by hearing, when in fact the agent didn't even have the instructions or the principal to act in that particular regard? The court said that there was no contract between the owner and Edward Gandel himself, since the contract was not purported to be made with him personally, but rather with Gandel and Sons, the supposed principal. There was also no contract between the owner and Gandel and Sons because Edward Gandel had no authority also to even bind the firm in any way. Therefore, the apparent contract between Edward Gandel and the owners was void, even though the parties transacted face to face. The plaintiffs, therefore, could recover the goods from the third party, since they did not acquire any title to the goods. So, by way of a recap, what we have done so far under unilateral mistake is this. For unilateral mistake, we have mentioned that before you can actually find that a person has entered into a contract under a unilateral mistake, and you want to find out whether that transaction is void on grounds of mistake or voidable by reason of misrepresentation, first of all, to make your work easy for yourself, find out whether the transaction was face-to-face or it was in writing. If it was in writing, we made our work very easy. by referring to those cases of Candy and Lindsay and the case of Keynes Norton Metal Company Limited versus Edridge. You remember these cases? What did they say? Now, if it's not face-to-face and it is writing, the focus of the court is whether you had in mind a definite and identifiable person with whom you intended to contract and not the rook. That's the focus of the court, if it is not face-to-face and it is writing. Now, beyond that point, if that is the case, that the court will find out whether you intended to deal with the one you had in mind. Candy and Lindsay, you remember what happened? In Candy and Lindsay, the rook made it look like he was Blankiron and Co., and that Blankiron and Co. was in existence. That is why the court took the view that because it was in writing, and the seller had in mind a definite and identifiable person with whom they intended to contract, then the whole transaction becomes void. And if it becomes void, you know what happens? It means that the seller can actually transfer the goods. Then the seller did not transfer any valid title to the rook, and the rook did not transfer any title to the third party, and so the owner can recover from the third party. You remember also in Keynes Norton Metal Company Limited, what we said was that the rook said it was writing under the letterheads of Hallam and Co. Because Hallam and Co. was a fictional company, the court took the view that then it's not be void on grounds of mistake, it would rather be what? Voidable. And if it was voidable, since at the time, the rook had transferred to a third party who bought it for value in good faith without notice, and it means that the rook had acquired, the third party acquired a valid title. Remember these two cases, Candy and Lindsay, and the case of Keynes Norton Metal Company Limited versus Edridge. But these ones were when it was not face-to-face. But when it is face-to-face, you remember the case that we looked at, Phillips and Brooks. Well, that's why he said, I am Sir John Bullock. The court held that since it was face-to-face, the presumption will be that you intended to deal with the one you saw by sight and then by hearing. The transaction therefore will not become void, it will become what? Voidable. And if it is voidable, it means that it will continue to be valid unless you have taken steps to rescind it before it was given to a third party. But since you have not rescinded it, the third party acquired a valid title, so the owners could not recover from the third party. Now, beyond that point, we went to Ingram and Little, which I will not go over because we appear to have a problem with the conclusion in that particular case. But let's go to the case of the Lewis and Avery, which followed Phillips and Brooks. And Lewis and Avery, even though because it was face-to-face also, the court took the view that the presumption applied, that the owners intended to deal with the one they saw by sight and then by hearing. The transaction therefore did not become void, it only became voidable, which means that it will remain valid unless and until steps are taken to rescind the particular transaction. That is the case of Lewis and then Avery. And the Lewis and Avery, we have our authorities to over there. Now, so the recap of the contract interpretation is that if it is face-to-face, we presume that you intend to deal with the one you saw by sight and by hearing. The transaction would therefore not be deemed to be void, but rather be deemed to be voidable. But that presumption is rebuttable. And it is rebutted when you have the rook proven to be as an agent of the principal. In that instance, the transaction will be rebutted, in which case the transaction between the owner and the rook will be deemed to be void, and the rook will not have transferred any valid title to the third party, so the owners can recover the goods from the third party. And the authority for that is Hardman and Booth. So bear in mind these particular principles that we have gone through, because that is what summarizes the law on unilateral mistake as far as the law is concerned in relation to unilateral mistake about whether the agreement was actually done in a way that you can conclude that the transaction between the owners and the rook, whether it was void on grounds of mistake or voidable on grounds of misrepresentation. The next lecture we shall discuss an essential case, which is the case of Shogun Finance Limited versus Hudson. That is the only case we shall discuss in the next lecture. And by the time that we discuss this particular case, because you must have already discussed everything that you know on Phillips and Books, and you have a firm grip of it, you should be able to tell the conclusion in the case even before I let you know what the holding is. So the next case we shall look at Shogun Finance Limited versus Hudson, so that we shall find out how the court deals with such particular issues when there's a mistake. That case poses a very serious and complex issue because we sometimes have to go through a process to find out whether indeed the transaction was even face to face or not. Your knowledge on unilateral mistake can never be complete without knowing Shogun Finance Limited versus Hudson. And that's what we shall discuss next. But for now, this is where we shall pause for this particular lecture. And then we shall continue with our discussion on Shogun Finance Limited versus Hudson. Thank you.